Good morning, Your Honors, and may it please the Court. My name is Sarah Stewart, and I, along with my partners Jeff Fabelman and Jennifer Hagerman of Birch, Porter & Johnson, represent defendant appellants Douglas Southard and the Southard financial entities. At this time, I would like to request a reservation of 3 minutes for rebuttal.
All right, let's show that. 3 minutes reserved for rebuttal.
This appeal presents a critical question about the outer guardrails of causation in professional negligence and oral contract disputes, particularly where the resulting damages are from a voluntary settlement of a claimed right to attorney's fees. In 1998, defendant Douglas Southard provided payment scenarios to plaintiff Julie Bartholomew, a licensed Tennessee attorney, for a fee of $250. Ms. Bartholomew sought to manipulate the division of attorney's fees between her and her client after a disagreement arose from a 1997 structured settlement relating to their customary 1/3 contingency fee. In a highly unusual arrangement, Ms. Bartholomew sought to accelerate her receipt of attorney's fees over the period of the structure due to her age for her benefit, while her client requested that she receive those fees 1/3 over the period of structure as they came due. Breach is not at issue in this appeal. When those calculations were sent to Ms. Bartholomew's office, defendants did not transmit a reduction to present value for 2 payments that would come due in 2015 and 2020. Ms. Bartholomew proposed this modified agreement, the assignment.
Let me ask you, so the miscalculation was only on 2 payments?
Yes, Your Honor.
Not the remaining payments?
Yes, Your Honor.
Period. Okay.
Yes, Your Honor. Defendants were asked only to look as to 8 lump sum payments. It was a 3-part structure. The majority of the payments were monthly compounding interest payments. Those 8 payments related to $900,000 of the settlement from Mr. Sprinkle's late wife's wrongful death, and the acceleration was as to the first 6 payments. Mr. Sprinkle testified at trial that at the time they entered into this new fee agreement, she did not advise him to seek independent counsel, and that it's undisputed that the acceleration itself was for plaintiff's benefit due to the age difference between her and her client. Years later, after Mr. Sprinkle did consult independent legal counsel and attorney Bradford Box, he stopped making payments to plaintiff, requested a copy of his file. None was produced for many months, and instead, plaintiff initiated a lawsuit against Mr. Sprinkle to recover unpaid legal fees, which indisputably placed at issue the overall reasonableness of her and fairness of her fee at its inception. Plaintiff agreed to voluntarily mediate that litigation to be conducted in April 2013. By that time, she was in a disputed litigation with her client, had placed the reasonableness of her fee at issue, and Mr. Sprinkle had filed a complaint with the Tennessee Board of Professional Responsibility. It was not until the eve of mediation that Mr. Sprinkle's counsel discovered and shared with Ms. Bartholomew that the 2015 and 2020 lump sum fee split had in fact not been reduced to present value, and thus, if those payments came due, they had not yet, the amounts and the assignment were inconsistent with the representations made by Ms. Bartholomew to her client, Donnie Sprinkle. Those calculation errors were then confirmed by defendant Douglas Southard. At trial, plaintiff testified that she concluded on that discovery alone, without any research, without delaying the mediation, purportedly on her own conclusion and the advice of her then counsel, Melissa Williams, without seeking to modify the agreement to be consistent with the party's intent, that the assignment was unenforceable and she had no choice but to forfeit her right that she claimed at trial was over $1 million in additional attorney's fees. There is no evidence or law cited in this case, apart from plaintiff's own speculation and the conclusion of her counsel at the time, that but for the 2 calculation errors, plaintiff would have recovered those fees from Mr. Sprinkle. The trial court nonetheless awarded plaintiff just over $1 million in damages, finding the causation to be that Ms. Bartholomew had determined that she was required to forfeit those fees based on the calculation errors. In addition, the trial court awarded significant prejudgment interest in this case. This judgment cannot stand. First, this court can decide this case on de novo review of the issue of causation. There are very few, if any, material issues of fact that came out were disputed at the trial in this case. The question is whether plaintiff was able to establish by preponderance of the evidence the essential elements of her case, including, of course, both cause and fact and proximate cause, and that the damages that arose from that causation was the totality of the underlying fee that was never proven. Second, the trial court made no findings of fact or conclusion of law on the affirmative defense of comparative fault, despite undisputed evidence that plaintiff's own actions caused or contributed to the dispute that arose with Mr. Sprinkle. And finally, the trial court erred in awarding significant prejudgment interest in this case. First, as to cause and fact. To establish causation for the damages claimed here, plaintiff must show the assignment was an enforceable fee agreement, including the acceleration she contemplated. But for that enforceability, absent the calculation errors, there is no harm here. Our courts have found a way to address professional negligence claims that involve underlying litigation in legal malpractice cases by requiring that the underlying right to recovery be established to support cause and fact in cases where the damages are tied to the ability to recover that underlying legal right. This is not an additional requirement exclusive to legal malpractice claims, but as courts have described, a way to prove causation of the full value of damages claimed from that underlying legal right. In Sheeran v. Seaman, the Tennessee Court of Appeals has said damages exist only where they would have resulted from the underlying dispute, but for the attorney's malpractice. Here, plaintiff did not put on proof that she otherwise would have been able to enforce the fee, which results in an unproven windfall. Of course, as your honors are familiar, the enforceability of an attorney's fee agreement considers whether it's fair at its inception, whether it was entered into in good faith, whether the client fully understood the contract's meaning and effect, that they shared the same meaning of the contract, and that the terms are reasonable. Those include the time and labor required, the novelty and difficulty of the questions involved, the skill to perform the services. That proof was not put on here. Second, even if plaintiff had established that the acceleration was permissible and her fee was reasonable, she was still required to tie the loss here to the calculation errors, which she cannot do solely because of her speculative belief that the discovery of the two calculation errors that had not yet come due rendered her underlying fee agreement unenforceable. The sole testimony at trial regarding this issue was Ms. Bartholomew's belief and the belief of Ms. Williams. When questioned, both confirmed they performed no research to reach this conclusion. No judge made a determination in the underlying case. This is as if plaintiff cites regularly to Hale v. Ostro, a simple negligence case, a simple case determining causation. A plaintiff is on a sidewalk. She sees some upcoming overgrown bushes, and so she steps off the sidewalk, ends up injured on another property, but wouldn't have been in the street in the first place had the upcoming overgrown bushes been there. This case is as if that same plaintiff was already walking in the street, tripped over some concrete, and then claimed without any other circumstantial or direct evidence that she would have returned back to the sidewalk before the overgrown bushes without them being here. Plaintiff was already in a dispute with her client, who had raised affirmative defenses. The reasonableness of the overall fee had been placed at issue, and she had a pending complaint against her before the Board of Professional Responsibility. The court determined on that speculation alone that there was causation as to the resulting damages here. That is insufficient under applicable Tennessee law. I'll point the court to Morrison v. Allen, which we described more thoroughly in our brief, but is another professional negligence claim where the court considered to be speculative and insufficient for a court to infer evidence that a plaintiff would have acted in a different manner had the underlying breach not occurred. Without additional evidence, that cannot stand here. So too, of course, was plaintiff required to prove proximate cause, which provides additional boundaries. Proximate cause provides that even if a defendant has breached their duty or breached a oral contractual agreement, defendants will not be held liable for injuries that were not substantially caused by their conduct. The preponderance of the evidence does not support substantial causation here. The trial court's order points to a few facts alone: plaintiff's decision to settle and a determination that occurred after that settlement by the Board of Professional Responsibility that the ethical claims against her by Mr. Sprinkle would be dismissed in a letter by Preston Shipp. Neither of those are sufficient to show substantial causation about plaintiff's voluntary settlement as to her underlying claimed legal right. Briefly, Your Honor, a few more issues. Damages in this case are a little tricky because, as you may have noted from the record, we actually lack a transcript to the sole testimony used to support damages in this case. A statement of the evidence was produced instead after an error by the court transcribing company led to the loss of a full day of the trial transcript. But the court's limited to damages that were reasonably foreseeable and were caused by the defendant's actions. Plaintiff at the point of voluntary settlement had received additional benefit from the acceleration of those fees, and the court did not consider the value of what she received earlier in the ultimate award of damages, nor did the court consider, as Judge Armstrong pointed out, that these fees had not yet come due at that time and were related only to a small subset of the overall structure. As to the issue of comparative fault, I'll refer Your Honors to my brief as I'm running out of time here, but I wanted to make one more brief point. The court abused its discretion when it awarded plaintiff pre-judgment interest for 10 years at a rate of 10% in this case, a pre-judgment interest award of around $200,000. This case is not one where the defendants had benefit of money that plaintiff had a legal entitlement to, and moreover, 70% of the damages in Trial Exhibit 21 from years 13 to 32 that make up the vast percent of the damages plaintiff would not have yet received as of the date of trial, resulting in an unproven windfall that is punitive to defendants and does not compensate the wronged party. With that, thank you.
All right, counsel? Carmen, let me have my iPad. Thank you.
This is mine.
Oh, that's yours?
May it please the court, my name is Robert Moore of the Memphis Bar. I represent Julie Bartholomew of the Fayette County Bar. I've been in the active practice of law for 41 years, and for that and other reasons, I strongly suspect this will be my last time at this podium. And if you will allow me, I'd like to tell you something that happened the first time I stood at this podium 40 years ago. I had been practicing for less than a year, and I was on my way up here because I can lose a case quicker than anybody. And as I went to get in the car, my partner, Jerry Mitchell, looked at me and said, "Now, Robert, when you walk in the door of the courthouse, the men's room is on the left, and just in case, wear a dark suit." That's the second best advice I ever got when it came to coming up here. But the best advice by far came from the Right Honorable Judge W. Frank Crawford. If you knew Judge Billy Frank at all, and you were friends with him, as I was, and he would give you a memento, he would write upon it something, and it was usually something like, "Always be the appellee." And so I stand here today following the best advice I ever got about coming up here, because Julie Bartholomew stands here in my shoes as the appellee, having prevailed completely in a 4-day trial before the Honorable Judge Joe Day Jenkins. She prevailed on everything. She prevailed on liability. She prevailed on damages. She prevailed in such a way that I will conclude my remarks, if you'll allow me, with what Judge Jenkins said when he was concluding his remarks. But as I stand here today with the benefit of being the appellee, the mantle of the discretion that my client's entitled to, the presumptions that my client's entitled to, I say to you that I'm looking at a very worthy adversary who has done everything well and professionally, and has, in a very colloquial way now, thrown everything up on the wall and see if something will stick. So many errors are being claimed against Chancellor Jenkins. The principal one, at least as I see it, is this issue of causation. She says that he didn't apply the right rule of causation. Well, when you read the record, and I know you will, and when you read his dictated findings of fact and conclusions of law, he cites to the very case that we cite in our brief, and he reads it verbatim. It's the Hale versus Ostro case, where he doesn't just know what Tennessee law is, for heaven's sakes. He reads it into the record as part of his findings of fact and conclusions of law. Hale versus Ostro, it's cited in his findings of fact. It's cited on page 29 of our brief. It's argued that there's no but for here, Judge. It's argued that there's no proof in this record that this assignment would otherwise be enforceable. Well, look, everybody knows I'm no contract scholar. I'm a tort lawyer primarily. But what I remember about contracts is if there's an offer, if there's an acceptance, if there's consideration, if there's mutual assent, and there's, I forget the last word, action on it, that's a valid binding contract, isn't it? And if this assignment that had been entered into between Ms. Bartholomew and her client, or former client, Mr. Sprinkle, did not have what I would call a mutual mistake of fact based upon these false, wrong word, inaccurate calculations that were provided, that would have been a completely valid binding contract that any judge, I would suggest to you, would enforce. So if you've got a contract that's on the record, if it is accurate, if everybody agrees, if there are no mutual mistakes of fact, that's binding. But when it's learned that there is a mutual mistake because someone that she hired as an expert witness, and we've all been there as lawyers, someone she hired as an expert to come in and do the calculations that she as a lawyer is not capable of doing, it changes everything, and lawyers know that. Lawyers know that when you have a contract that has that kind of a mutual mistake, that contract's going to get set aside. More so if there's an inequity, dare I say, between the parties, one being a lawyer and the other being a client or a former client. One being a case where it's the lawyer who prepared the paper and the poor client or former client who signed it. So everybody knew at that mediation, uh-oh. And uh-oh means this. Not only is that contract susceptible to being set aside, it probably will. And when contracts get set aside, it doesn't just end with where we are now. We reach back in time, don't we, and put the parties back where they were. That means that Ms. Bartholomew would have to disgorge $600,000 that she had been paid to that point.
Let me ask you, from reading your brief and also from reading the judge's findings, he credited your expert's testimony that Ms. Bartholomew committed no ethics violation and there was no violation that would make her attorney fee agreement unenforceable. If that's the case, is it the miscalculation that caused the loss, or was it actually her decision to settle the lawsuit that she brought against her client?
It was the miscalculation.
Well, why is the miscalculation the cause?
Say that one more time.
Why is the miscalculation the cause unless there's some proof or evidence that the agreement would not be enforceable? Obviously, you've got to modify any overpayment, but with regard to other payments, why would she not be entitled to those?
You know, I'm not sure that I'm following you, but here's what I think I heard you say. The chancellor did find that there was no ethical violation, and that's always been Ms. Bartholomew's position, and therefore she's not afeared of that as being a basis for setting aside the contract.
But the expert not only opines there's no ethical violation, but also says that the agreement is enforceable. Her agreement with her client is enforceable. Not unenforceable, but enforceable. It
would have been, as I've heard it said, but for the fact that there was a material misrepresentation of fact, a mutual mistake of fact, I beg your pardon. That's the problem here. That was a good contract, completely enforceable, and Ms. Bartholomew went to that mediation prepared to defend it until she learned there's a problem. There's that uh-oh moment when she learns by contacting Mr. Southard, and he comes back to her on the second or third opportunity and says, in so many words, you're right. We didn't do it right, and I apologize. Now, I'm taking some liberties with what he said, but when you read it, you'll see it exactly. He first said the calculations appear to be correct, and then he had a sleepless night, I think his testimony was, and he woke up and said, I don't think I did it right. And that's what changed everything. But for the fact that these miscalculations were made, and but for the fact you can't enforce something like that, we wouldn't be here today.
Well, you wouldn't be able to enforce the miscalculation, but she would be able to enforce her agreement to the extent that it was done correctly. And so there was still time, there were still a lot of payments left to be made, and the client here could have been credited with those overpayments, or she could have had to disgorge the overpayments,
And it was
but
that.
not affect the rest of her fee.
Well, I wish I had that crystal ball. But what she's looking at as a trained lawyer is when I have a contract that I don't know I can enforce, then I can't predict the future. I can't tell if I'm going to have to disgorge it. I can't tell what a judge is going to do in the future. I can't tell. And it's because of that miscalculation. And as the judge found, as Chancellor Jenkins found, that was the reason she did it. That was the proximate cause that she did it. And he said that that was a reasonable thing to do. Now, worthy counsel opposite also makes the very correct statement that the sole proof, the sole testimony issue of damages was from Robert Vance. And that was the expert that we hired. And I think everybody here may know him or know of him, but certainly Chancellor Jenkins did. And Ms. Shepard is right when she says that he is the only man who testified, the only person who testified, because although the defense hired a economist named Ralph Scott, I want you to note, if you hadn't already noted, Dr. Scott said out of his mouth voluntarily, I didn't calculate damages. Vance was calculating damages. I don't think I calculated damages. I'm just here to basically value certain aspects that might or might not be construed as damages. Judge Smith, that's on page 63 of our brief, that quotation. In addition to saying that very notable admission on his part that he did not do that, he further testified that what he was hired to do was very specific, and he was instructed, ignore income on the front end of this, ignore income on the back end of this, and just act like it didn't happen. Well, we can't do that. Now, Chancellor Jenkins, who is the one who was evaluating credibility in this case, looking at the witnesses, listening to the witnesses, he heard all that. So when he came up with a big number, there's a reason for that big number. It was, as my friend Ms. Shepard says, unopposed testimony.
And why do you get prejudgment interest on that big number?
Because it was, as the Chancellor said, thank you, that's how I'll end it. It was clear that plaintiff's claim more likely than not be successful on the merits. This isn't a case that was close.
Yeah, when is prejudgment interest normally starts when there's an amount that should have been paid that wasn't paid. In this case, we're determining what she is now owed. So why would there be prejudgment interest at all?
Because she was cut off at the moment of that mediation amendment, minute that agreement was made, from any future stream of income.
And the amount that she was cut off on is what amount? It wouldn't be the entire $2 million, $1 million, would it?
No, sir, but I can't answer your question specifically, but I can point you to where the answer is. Ms. Bartholomew created a chart, for lack of a better word, that was made an exhibit to this record, and it's her handwriting, and it shows numbers and what the prejudgment interest is, and the Chancellor in his ruling made reference to that, saying how helpful it was to him, and that's where he got his numbers from. So I'm sorry I can't give you a precise number on that, but I can tell you where the answer lies, and that's where it lies.
But you do agree that you wouldn't get prejudgment interest on money that should not have been paid in the past. You get prejudgment interest on money that was owed in the past, not going forward. You said she missed a couple of payments.
Well, yes,
maybe
sir,
you
I'm
get
trying-
prejudgment interest on those,
I'm trying to understand where you're coming from, but I
but how
think
do
I
you get
understand.
prejudgment interest on the money going forward, is what I'm trying to figure
You
out.
get prejudgment interest on money you were owed,
Right,
and I think you're saying that, and I agree with you.
okay. And so now I'm just trying to figure out what was actually owed at the time that the chancellor entered his judgment. What was actually owed that should have been paid in the past?
I apologize again, I don't know that number, but I can tell you where the answer is.
Okay,
And it's in that trial exhibit that he made reference to in his ruling.
and did the judge use that number to calculate prejudgment interest, or he just gave prejudgment interest on the total amount of the judgment?
What he did was he looked at that and made his calculations based on that, and I can't tell you now
Okay,
with any certainty where he cut it off, if ever. Let me say this and I'll sit down. It hadn't been said. It's kind of sort of been inferred, and I don't think maliciously, but Ms. Bartholomew, as a young lawyer, did a really good job on this case, and she looked and reached out for help when she needed help. And when this case got settled, it was settled at a judicial mediation settlement conference with the great Judge Daniel Breen presiding. We all know what a great judge he is. We all know that no questions would have been unanswered at that mediation. We all know that he would not have let Mr. Sprinkle agree and walk out of that settlement conference without fully understanding what how much money it was, what it means to have a structure, that the $750 paid up front was intended for attorney fees, so we wouldn't get in this. And the reason we're in this is because Ms. Bartholomew did not want to sue her client. When he wanted to change the deal, she didn't want to sue her client. And so she worked out a deal. But we all know that when you have a structure going forward, the structure is based not upon the life of the old lawyer. It's based upon the life of the young widower. And so it's quote, to her benefit, yes, that the attorney fees be advanced under this revised way of doing things. That way she gets the money before she's 10 years in the grave. So there's no evil intent here on the part of Ms. Bartholomew. I beg your pardon for raising my voice. There's no anything here going on other than a young lawyer who reached out for help from an experienced financial guy trying to make it right with her young client, and then being led astray by that financial guy. That's why we're here. Any questions?
seeing none, thank you, Ms. Moore.
Your Honors, Judge Armstrong's questions are absolutely correct as to what happened here. Plaintiff's decision to voluntarily settle her case with her client is the causation of the loss of her damages. Chancellor Jenkins did not find otherwise. Chancellor Jenkins pointed to the decision to settle as the causation in this case. And Chancellor Jenkins pointed only to the decision of the Tennessee Board of Professional Responsibility as to what he described as the ethical issues in this case. As Judge Armstrong pointed out, plaintiff's own expert testified her fee agreement was otherwise enforceable, and although I have great respect for my colleague, it was not determined by Chancellor Jenkins that there was ever any agreement that plaintiff and Mr. Sprinkle had a common understanding about the $750,000 original payment in the structure. They had a verbal agreement to a 1/3 contingency fee that was renegotiated in a 1999 assignment. I'd point your honors to the stipulated timeline in this case. It helps to see the steps that occurred in this case. They were in a dispute. She renegotiated the fee agreement for her own benefit due to her age. Her client testified at trial that he believed that she was supposed to be acting in his best interest. If the fee agreement was enforceable, if there were no ethical issues at this case, there was also guiding case law available to plaintiff at both the time she entered this assignment and at the mediation in White v. McBride that says attorneys are not going to be punished or unable to obtain reasonable fees for what that court described as innocent snafus. If that's the case here, as plaintiff has always proposed, then she remained able to recover money from Dawn Sprinkle. She did not. She voluntarily settled a disputed claim. And whether the question in this case is whether, but for the calculation errors, she would have recovered over $1 million in this case. That was not established by preponderance of the evidence at trial, and thus defendants request that this court reverse and enter judgment in favor of defendants. As to the applicable standard of review, unless the trial court made a specific factual finding, this court can evaluate the record and determine where the preponderance of the evidence lies. Otherwise, as to the application of law, of course, the review here is de novo. Without any further questions, Your Honors, we appreciate your time today.
Thank you.
Thank you.
All right. All right, you're excused. We'll take your case on advisement and work to get you an opinion.